Can I kick out other co-owners or co-founders of a business? More plainly stated, can owners of a business be removed from that business by the other owners? Well, the answer is generally yes, but with caution. There are numerous considerations and particular outcomes that may not be desirable or favorable to all the members in that situation. So to start with, if this situation arises where you want to remove an owner from the business, you have to look at the provisions of any ownership agreement in place. Now, an ownership agreement for a partnership is a partnership agreement. For an LLC is an operating agreement or LLC agreement. And for a corporation, it's a combination of the articles of incorporation, bylaws, and shareholder agreements. Okay, and oftentimes you'll have a completely separate agreement called a buy-sell agreement. This may be present in a partnership, in an LLC, or a corporation. And a buy-sell agreement specifically deals with the issue of what happens if an owner leaves or is pushed out. Okay, in those situations, you will conform to what is in that agreement. So if you had the foresight ahead of time to lay out those provisions and how that would work, then you'll follow the provisions. Now, if you do not have a ownership agreement that deals with buy-sell provisions or a separate buy-sell agreement, you're going to have to depend upon the default rules under state law to determine how and if you can kick an owner out of the business. And generally that's going to change based upon the type of business entity. So to start with, a partnership. Now, a partnership is the most basic form of business entity. It's two or more individuals carrying on any form of commercial activity for a purpose. You don't have to file anything. You don't have to do anything special. Now, if you want some of the particular special types of partnership, like a limited partnership, a limited liability partnership, those types of things, then you do have to file. But a partnership, by and large, a general partnership can arise by default. Very simple form of entity structure. Now, if a partner leaves or is pushed out of the business, the general rule is that the business itself must be wound up and dissolved, and the liquidated interest of that partner paid out to each partner based upon their percentage of ownership. Now, if you do that, can the other partners get back together and reform the business and continue on? Yes, but you have effectively ended the business venture. Any contracts there, any other claimants against the business, debtors, creditors, that type of thing, you would have to pay them out. So in essence, you're tearing apart, you're destroying the business to push out a partner. So in the absence of having specific provisions in place in a partnership agreement that allow for the pushing out of a partner dissolves the business, and that may be a very unintended consequence. So once again, it can happen and there is a way for the business to reorganize and keep on going, but there are tons of repercussions to that decision. A limited liability company, this is where you have a separate legal entity from the owners that you have to file with the state to bring into existence, and generally you're going to have an operating agreement. But if you don't, then the default rules apply as well. And the default rules are very similar to that of a partnership, except that the default rule is not that the LLC dissolves in most states. The rule is that any member would be subject to an accounting if a majority of owners, by default a majority, were to vote to push out an owner and to buy out their interest, then once again you would have to do an audit of the business and offer that member their rightful percentage of ownership in the business to be bought out. And the accounting could take place, through multiple valuation experts to come up with a solution. If you can't come to a agreement on what the business is worth in the terms of buyout, then it could be a forced buyout through the court, and the court could order a valuation in that way. And in the event you cannot come to a resolution, the court could actually order dissolution of the business to make a liquidation as the backdrop. And again, that would be very similar to a partnership where you have to shut down the business, you have to shut off all contracts, you liquidate all the assets, and you pay out the owners, and then you have to restart it. So once again, it's a very difficult process if you don't have rules in place. Now, the default rules are, yes, a majority of owners can vote out other owners and repurchase their interest pursuant to state law, but once again that can get very messy when there's no provision in place for the valuation of the business. So again, unintended consequences. Now, in a corporation, this is where the owners are the most removed from the corporation. Okay, and generally the ownership interest in a closely held corporation is not liquid. That is, it's very difficult to sell your ownership to others. In a public company, that's not the case. You can easily sell your interest to others and get out of the company and things like that. But focusing on whether you can actually kick out a shareholder from the corporation, if you don't have provisions in the bylaws or in shareholder agreements for that to occur, you resort back to the default rules under state law, and the default rules would be majority control again about recalling a shareholder's interest. You would again have to go through a valuation process to determine what is the value of the ownership that's being repurchased. And if you can't come to that valuation again, there is no forced procedure there to come to a valuation. So if the court were not to draw a valuation, you'd again potentially order the liquidation of the business. So it's very similar in that way to an LLC. But most state laws, again, if there is some cause or reason for the court to order the cashing out of a member of the corporation, then that could be ordered. But without valid cause or justification for that order, it's a difficult process, and again can have repercussions. So with that being said, again, the shareholder being cashed out does have audit rights to make certain that what is the value of their interest and that type of thing. And generally on the other side, that shareholder can force the corporation to buy out their interest or have the ability to sell their interest to others. So that's the general approach that you have to take for determining whether you can kick out a co-founder. The answer is yes, but with caution, and it can be a very long, arduous process with many unintended consequences.